Hello and welcome. My name is Mark Blatstein, the physician founder of Physician Pre-Sentence Report Service. Welcome to my new website. Here's the name at the top, Physician Pre-Sentence Report Service, phone number 240-888-778, and my email address. Today, I'm going to discuss the difference. We'll jump over here to who carries the most weight, who's the most important, the judge who sentences you, or the probation officer who meets with you, does the investigation, and reports their findings to the judge. And so that is going to be the topic of this particular video. Who's most important, the probation officer at the interview or your judge at sentence? But ultimately, you're going to control your future. And so who are you going to need on your side? So let's continue. As I said, I'm Mark Gladstein. I'm here to help you on your journey. And I too was convicted of a felony, but I got my medical license reinstated and got my career back. I can't make any promises. Anyone, if any attorney or any consultant tells you they can promise you, or they know the judge, or that they know that this will happen, just move on, because no one in life can make you any promises for anything. But preparing for your pre-sentence interview, I can promise you, is probably the most critical thing that you have going for you right now. And so to at least try and make this a successful journey, at least from my experience for myself, because I was not prepared, and there are many pitfalls that I'm going to try and impart to you from my experience so that you won't go through the same disappointments. One of them is preparing for release before you even get to your pre-sentence interview. And it seems counterintuitive. And on the surface, it probably seems you're correct that it is, but really it's not. And it's a step in the right direction if you can just do this on faith. You may experience something you may do something completely different at the end of your journey once you're released from prison, but at least having some sort of plan for a daily routine as to what to expect on your first day of prison when you get there is a good start. Because I didn't know what to expect. I didn't expect to be thrown into this isolation or the shoe because my records were not there. It was just totally, this all could have been prevented had I had some degree of knowledge ahead of time. And so I digress. A crucial factor is whether is this your first offense or have you been here before? It's not a trick question. It's significant because part of your background, your lawyer is going to know the nuances of the law, most of it. They're not going to know the nuances of you. They're going to know, or they'll find out eventually, parts of your background. Only you're going to know your whole background. So to start, everything's going to start with you need legal representation. You can't be an ostrich. It's not going to go away. Don't bury your head in the sand. There's a reason why all the cartoons have the picture of the ostrich with its head in the sand, because its rear end is blowing in the wind. It's something still going to happen. So I have a series on my website of 14 questions that you need to have answered, or would be good for you to have answered before you actually decide that this attorney is good for you. But I'm going to at least go over a few. Do they practice federal criminal defense in federal court? It seems like it's straightforward. Is there experience with cases like yours? Sounds pretty straightforward, but it's not. I had a client who, his attorney, after he was sentenced, and they, wound up, with me, their attorney just did personal injury work. They did some federal work, but not criminal. And so, it's not wrong. It doesn't do any good to learn after the fact and have buyer's remorse, regarding, probably one of the most important legal decisions or life learning decisions you've ever had. Three, if you want to go to trial, just feeling you're right is insufficient. I give you FTX, Sam Bankman-Fried, and Elizabeth Holmes. Why do I say that? You want to go to trial, the Department of Justice has a conviction rate approaching 98%. And so you want to ask your attorney, your counsel, they say, okay, let's go to trial. You want to know how many trials they want. Seems like pretty straightforward to me. Ask them. I wanted to appeal parts of my indictment. First of all, my first mistake was I never asked my attorney how many appeals they want. The second mistake was I didn't ask them the following question. I just assumed, and if you're older like I am, you should know what assume means. But I assumed that the judge is going to say okay, or they're going to say no. Door number one or door number two. I never assumed that there was a door number three where they turn around and send me back to prison. That thought never crossed my mind. So that's why, remember, the Department of Justice has over a 90% conviction rate. So you want to ask these questions. Sam Bankman-Fried, you don't want to anger the court before you ever get in front of the judge. If you're on pretrial release, or if you're on your own personal recognizance, whatever you're doing, if you're, you don't want to show up with, a Alfa Romeo or just expensive vehicles and multiple homes, and then you want to plead innocence at sentencing. You don't want to anger the court. That's playing Russian roulette. At least if you go gamble in Vegas, you're not, it's not that, it's a big difference between that and getting like a gun, a 5-shot gun, putting 4 bullets in the chamber and revolving it, and then a revolver, and then putting a gun to your head and trying to pull the trigger and hoping that the gun doesn't go off. What, in their opinion, regarding providing your sentencing length and placement request, all previously discussed with the officer, to your probation officer, with your narrative and release plan guidelines before the pre-sentence interview? This is not probably a great sentence. Essentially, you want to ask your attorney, what's their feeling on giving at the end of your pre-sentence interview or discussing with the probation officer that you want to have included before you meet with them officially, that you want a week or two before the interview, you want to provide them with your complete narrative of your story, of your personal narrative that counters the indictment. You also want to have a realistic sentencing guidelines reviewed with the probation officer by your attorney, so that it can be possibly accepted by the probation officer, as well as if you have a specific placement request, just one. And then we have a BOP placement packet that we can present to you so that you have reasons, program or location or medical reasons to go along with that placement request. Then preparing for the interview. And this backs up some of what I'm telling you. Preparing for your interview, your probation officer requested for your interview. Judges across the country have been interviewed. And there's two common themes here, where judges say, these are two judges that were interviewed by Alan Ellis, who's been in practice over 50 years, was president of the National Association of Criminal Defense Lawyers. And Judge Patrick Schultz was quoted as saying, it's surprising how many otherwise competent attorneys punt at the sentencing hearing, where they're not prepared because they haven't gotten the sentencing memorandum to the judge 10 days before the sentencing hearing, or if they have, it just quotes Booker, which the judges already know, or Judge Scalia, who says, don't wait to think about sentencing advocacy, since 99% of all federal criminal clients will be facing sentencing. Start the case for sentencing early on. In other words, as soon as you get a client, 90% or over 90% are going to be found guilty and will have to go to prison. And so spending a lot of, the majority of your time investigating the case, knowing that the defense is going to have to be mitigating the damage. Your probation officer will have a list of documents that they're going to need copies of. Do not wait. You should have everything copied, organized, spell checked, including your personal narrative and release plan. So why narrative? Judges understand that crimes do not happen in a vacuum. So to humanize yourself to the court, the only person that they do not know is you. They know that the attorneys are paid, your attorney's paid to keep you out of jail. They know that the Department of Justice wants a conviction. The prosecutor wants you in prison. And so how do you help the judge? Humanize yourself to the court. You need to humanize yourself. Department of Justice has already told your story. They've told your autobiography to the world. They've released worldwide your indictment. If you do nothing, that is all your judge is going to know. But if you've taken the time to write a well-written personal narrative that shares your life history while accepting responsibility and remorse for the victims that have been harmed, and you've had someone either or someone professionally that's worked with you to help write this personal narrative, someone like myself, someone else, and you've gotten it to the probation officer with all of copies of everything else they need a week or so before your interview, that's going to pay dividends in the end. First of all, the probation officer is going to feel like you've respected their time. Second, they'll have time to enter all of this information because everything you're now giving them will help them fill out their pre-sentence report worksheet, which allows them the time when they meet with you to get to know you personally, asking any remaining questions they may have. To date, the Department of Justice, as I said, they've released your story or autobiography in the form of your indictment. So if you don't agree 100% with your indictment, then you have a choice. You can tell your story through your personal narrative. Call me. I'm available to answer all your questions. This is a YouTube I released in June of 2023. You can go look it up. It's regarding your probation officer and the power of your narrative. The probation officer conducting your interview has sway with your judge and can help them answer these questions. Judges want to know what you did. After learning why, did you take responsibility for your actions? That's a big thing. Do you have remorse for the harm you caused to your victims? Probation officers look for answers to some of the most pertinent considerations: the nature and circumstances of the offense itself, and the offender, your personal history and of individual characteristics. This is all covered. These are specific trigger points, but you've covered this if you've gone through a personal narrative. E factors refer to circumstances that may warrant a departure. These factors include aspects of the offense or the offender's background that the guidelines do not accurately consider, the defendant's role in the offense. You don't want to be considered a organizer or the ringleader, because if you are not, but it's written that you are, that's going to increase your security level. The defendant's criminal history, hopefully you have none. If the probation officer gets the wrong impression and they say you have a criminal history, you need to correct that. The presence of substantial assistance provided by the defendant to law enforcement, that's a big deal. The defendant's medical or physical condition, mental illness, is there a current treating therapist? If there is, and it's applicable, if your attorney feels it's applicable, they may be requested to appear at sentencing. Was there a history of significant abuse or trauma growing up? This is all part of the narrative. Was substance abuse involved in the charge? Part of the narrative, and may qualify you for RDAP. Did you start treatment on your own before the indictment, before the guilty hearing, or before the pre-sentencing interview or sentencing? This is all very significant and should be in your personal narrative. Plus, you want to get documentation should you have started this treatment on your own before any of these specific data points, so that you can provide it to your attorney and have it included in your pre-sentence report. The judge is looking to read this. F factors, nature and circumstances of the offense, the history and circumstances of the defendant. The sentence must reflect the offense's seriousness to promote respect for the law and provide just punishment. There is a need to afford accurate deterrence to criminal conduct. The public must be protected from further crimes the defendant commits. The defendant must receive educational and vocational training, medical care, and other correctional treatment. This is where the place you are picking for placement should be one location, and it's based on education, vocational training, medical care. And I have all of those itemized in each of my prison packets, but you can go online also. So the answer to the first question out of the box was, which can impact you the most? Before sentencing or the interview, the probation officer or the judge? The answer is both. We all get one chance to make a great first impression, period. In your interview with the probation officer, they can sway the judge. So that's your first impression. If you kill it, then you're done. You can kill it positively, then that's great for you, because they can make they can sway the judge in your behalf. If you create a bad first impression, then you can be toast. But either way, right after the interview, your attorney will send a follow-up letter or email letter to the probation officer and get in either the placement request, clean up if there are any questions that were left over from the interview. Once the judge gets the probation officer's feedback, now it's up to use your narrative as your allocution when you're speaking to the judge. That conversation is called the judge, and you speak from the heart. I had a client that I think he was facing 100 and some odd to 100 and I think 89 months was his sentence. And when he got into court, the judge was, read his narrative, and everyone was being swayed. He had a great narrative, a great people that wrote letters, but his allocution was phenomenal. And it dropped down to, I think, 84 months. It can happen. Positive things can happen, but you don't want to have no BS. Judges have great bullshit detectors. You want to be honest, heartfelt. By this point, you've practiced and you own all the details. You know your life story. So now it's time to share it and know that being nervous is typical. Several more points. Actively listen when you're in the interview. Listen, arrive early, be authentic, empathetic, be mindful of your body language and posture. All this goes for also during sentencing. Choose your words wisely. Come prepared. Don't forget the follow-up. Counsel will do this for you during the interview. Dress the part, know your audience, be respectful, make a connection, both an eye connection and facing the judge and the probation officer. It's called modulate your pitch, tone of voice, mirror. It's called mirroring. Mirror the person you're talking to and turn that phone off. I thank you for taking the time to listen to this YouTube today. I wish you the best of luck if this YouTube catches you, hopefully before you've had your pre-sentence interview. But anyway, along this journey, I wish you the best. Any questions, please don't hesitate to give me a call. Best of luck, and thanks for paying attention and for taking the time out of your day.